we have not so much a reading week, but really basically like a gap. And the reason I initially left that gap there was to provide the option of an optional revision seminar. So it's not in the usual timetable, so obviously it's entirely optional. It's not the sort of one for which I would take a register, because obviously you didn't know about it. But given I've just had this query about the exam, I'm going to guess that probably at least one person would want to attend it. Would anybody else like to attend this class? Okay, that's fine. Okay, yeah, that's plenty of people. That's fine. I mean, I pretty much would hold it for whoever showed up, but I think it's perhaps a bit more interesting if there's more than sort of one or two of you. Okay, so what we'll do then is have perhaps like 1 till 2 on that Thursday, which is the 5th of December. We have this room. If it turns out that's not the case, I will find somewhere else, but we should have this room, and we'll have a sort of revision class. And you can, what I will usually do is ask you to send me queries in advance. Or obviously you can sort of come to the class, you can ask questions. We'll go through both a sort of basic overview of sort of what are the themes. I mean, obviously we're going to do a little bit of that in this class as well, right? Because we're starting to repeat a little bit the things that we already know, especially because today we're dealing with infringement, but you're already familiar with the relative grounds for refusal, so this should be perhaps a bit more straightforward than normal. So we will also discuss this question about, how do you approach an exam when it's a take-home exam? Now, my understanding, I thought that I'd just sort of digress you from my further announcement, which is that is it right that for maybe at least more than one of you, you've not done law exams before of this particular kind? Or is it, so can you explain, is it a question of this particular format of exam, or is it like a UK common law type exam, or what?
Both, because we did, like, I'm speaking generally probably for all Germans, that we have a pretty clear structure in Germany. So we have a kind of writing, and we get cases that we have to solve in the exam.
Oh yes, I'm familiar.
And we have like a
Yep.
structure. It's given structure, just do. And I feel like here is more about your freestyle.
Yes, it
right?
is.
And
Yep.
it's really making me feel uncomfortable because
because
I don't know.
This happens every year, and not just the German students.
I'm getting judged harder because freestyle, obviously.
Yep.
So I just want to make sure which kind of structure is there, or how is the general thing, how we writing, like introduction, body, conclusion.
Yeah. So I will just say immediately, it may not be overt. There is a structure, it's just hidden. It's just hidden. So you can absolutely, work out a way around it, which will be, I think, comfortable. So I think it sort of gives the impression of, I have these thoughts, and I'm giving you my thoughts and some evidence for my thoughts. And it seems like it's quite free, but actually underneath, you will find that there's a sort of skeleton to it. So yes, we can definitely go from that. I wanted to ask, since this is perhaps a feature of the German educational system, for our Chinese cohort, would this be an unusual kind of exam structure as well? I'm just going by anyone? The same? And anyone else? I know we have students from lots of different jurisdictions, and that's just perhaps the two bigger ones. Anyone else? In terms of the kinds of exams that you're used to?
Is it essay style?
Yes, for my course it is. For other courses you might have sort of problem questions.
So can we follow the essay steps?
For my course it tends to be, because the sorts of things that we've done in class, obviously this is going to be a clue to the kinds of things that I can assess you on, right? You have a formative, that is an essay. This isn't always the case, but it tends to be a clue that you will be assessed on the kinds of things that we cover. At least I hope this isn't a surprise. Perhaps this is one of the things that I assume that everyone sort of figures out.
So you want to see in the exam thesis statement for each question, and you want to see our own opinion about the topic, or no, you don't want to see this as an essay style?
Okay, so I can't talk about the exam.
Oh.
But it has been approved, so I can definitely tell you that there will be an exam. Approved. So let's talk about the formative. That's an essay question. Yes, on... Okay, I have to admit that when academics set exams, we basically immediately forget what it is that we have set. And I can't actually now even
Distinction
remotely...
between brands and signs.
Okay, I will take your word for it that that is what the...
It's like,
Yeah,
something like that.
Okay, so I've given you a statement and then I've asked you to respond to it. Yeah. So with that kind of question, you will notice that in the in sort of the outline for the course, we're saying, well, what is it that we're interested in? We're interested in primarily trademarks and brands. So the way you regulate branding, but in particular looking at sort of trademarks as a subset of that. Now, if you look at now obviously we can talk about this because it's not summative. When you look at a question that has the words brand and a sign, like what do you think it is that I might be asking you to discuss, given what we've done in this course?
Distinguish.
Yeah, so one of the very first things will be, well, what is the distinction that we can draw between a brand and a sign? What is that? Again, we can share this, right, because we're not, it isn't summative. What is a sign compared to what is a brand? In what context have we used those two words?
Can you use the sign for a brand? No.
Yes.
Yes.
Yes, so that might be part of it. But
Yeah.
how do you potentially protect a sign legally in order to strengthen a brand? Yeah, exactly. So you're looking at sort of the outlines of those two concepts. And they're going to be, I mean, obviously with a question like that, there's a specific piece of literature that addresses exactly this question, right, by Jennifer Davis. So to that extent, it's perhaps a little bit more straightforward. But the idea is to sort of produce your own argument in response to it. So there's not really like a wrong answer. I'm generally sort of quite delighted to see someone adopt, especially, you know, a different view to how I might do it or how somebody else might do it. This is great, as long as you can sort of provide some evidence for it. Mm-hmm.
but regarding the formative assignment
Yep.
question, it was actually the difference between brand and sign regarding UK law and I think EU law. So
Question.
actually we can look that up, but you're gonna ask specific question. I know you can't answer that,
Mhm.
but let's say there is a specified question in the exam. Do we? And you said we're actually not allowed to use anything, so we have to know this. In
Well, you'll have a
advance?
week to prepare.
True, but there will be another question we're not having time to prepare, right?
No. You have all of them in advance.
All of them?
No, the whole
I think
paper
I
is
remember
in
that you
advance.
said in the first week that there might be one on top of that.
No, one that's compulsory and one section where you have choices.
Okay.
But all of them are available in advance.
Okay.
So it means that you can choose in advance.
Okay.
Yeah, no, that's a good question. No. The idea is that the whole, so probably exactly a week in advance, probably at 9 or 9:30 on Tuesday the 10th, I'll just release it on Moodle.
So since we're writing in the essay style, actually, we also have to use references.
So this was the other point that I was going to make. Obviously for your formative, the idea is that you should practice your footnoting style. Given that it's in advance of an exam, if you would prefer not to use OSCOLA and use like Harvard in-text referencing, fine. I'm not going to be terribly fussy about it, but you should know that for your essay next term, you'll have to use footnotes, so in that sense, it's better to practice. But it's up to you. Certainly when it's submitted, sort of written, it should be fully referenced with pinpoint. So I am quoting from L'Oreal and Bellure, this case, paragraph 46. That sort of thing. For the exam, absolutely not necessary. Pinpoints are not necessary. If you happen to remember, you know, amazing. But I would certainly not expect it, notwithstanding that you've had it for a week. I mean, I think that's not really the purpose of it. It's not sort of to test your memory, it's to test your sort of critical thinking. But you would have to say, this comes from this person's article. Ideally, you would have the article. So if you're someone like, when there's someone really prolific like Ilana Fima, it would help often to say, you know, which of her articles you're referring to. But at the very least, you would want the person's name. When it's a case, you would want the name of the parties. Ideally, whether it's the UK case or a reference to the CJU. If you have a memory blank, say the case with the perfumes, I will know what you mean. I will know that you mean L'Oreal and below. So, you know, even if in brackets you put like a little question mark, or you say the case about the whatever, the case about the toy car, I will know that you mean the Opel case. So yes, so you still need referencing, but it's, you know, it's reasonably generous, which I think is fitting under the circumstances.
So, like, just as an outline, so for example, for one essay question, you said like it'd be beneficial to have cases in there, some literature,
Yes.
some or probably some acts and all.
Yes.
On a general, what would you say would be like a minimum requirement for each good essay to have at least 2-3 cases, 2-3 literature? Is there something like that that you're expecting out of us?
Yeah.
Those are really going to be memory tested because case names, we know the principles and everything, like case names and names of literature and names of the acts and everything. Those we will have to memorize. So in terms of memorizing, is there a good outline of what every question should contain?
Yeah. I think the assessment is qualitative rather than quantitative. So in the sense that you could mention 10 different articles, and it may well not be as good as someone who's mentioned 2 and have managed to deal with them in depth or compare and contrast, or link that particular article and use that to critically assess a case, for example. So I actually can't answer that question because it will be context specific. If you are asked to discuss academic literature and you discuss none, it will be very difficult for me to find marks for you. And I will just say, I try very hard to find marks for students. You know, we all do. I mean, as a rule, my experience is that when I have given students work to mark other students' work, you're harsher than we are. Students are actually incredible, you know, so the idea is you have to answer the question. So, I mean, there's only so much, you know, I can do, but as long as it answers the question, it's not like I'm sort of ticking off saying you have done 5. But if you only say mention 3 cases and you've failed to mention a key case, you know, it doesn't matter how many others you have.
What is a good mark for this course? Like 60, 70? Because here the system in the UK is totally different.
That's
Because
a very
like when
good
I was
question.
doing my bachelor, 60D, it's like that. Here 60 is almost equal to D or something. So what is the minimum here?
So you all have to pass.
What is the pass here? 50, 60?
So it goes A is the top band, then B, then C, and then D is a pass. I'm just trying to think. I don't think anyone failed my course last year. If that's what anyone. There is a first time for everything, presumably, but
No, just asking. So in order.
I don't actually expect that from anyone.
No, just
you have
trying to
attended.
get a good grade. So just trying to know what do you mean by a good grade.
So if I ever mention sort of the idea of a good grade, I'm saying, are you meeting the requirements of the marking criteria that's sent out to you, and which I hope you have access to. This is the sort of the basic marking criteria that says A, B, C, D. Yes?
I've seen it last year.
Have you seen it? So it has sort of logically structured, well written. The big one is independent analysis of sources, for instance. The sort of things that tend to repeat, especially in the A band, are critical analysis of the sources, strong knowledge of the topic, sort of very few errors, that sort of thing. Anybody else about? So in terms of the structure, again, I mean, this is something that I would ordinarily sort of do in a revision class, but I think it sort of bears repeating probably now as well. You obviously want to have an introduction that demonstrates that you're going to answer the question. One of the very common difficulties in sort of coursework responses is that you might have a good response, but it doesn't actually answer the question. It seems sort of quite obvious that you should answer the question, but can sometimes, can be a little bit difficult. So you need to make sure that you're defining what it is that the question is asking in the introduction, and you're saying, this is how I'm going to argue it. This is going to be my position, and here are, say, the 3 main points that I'm going to make. And then my top tip is use headings and leave lines between your paragraphs. This is obviously largely kindness to the markers, but it means that the moment a marker opens your exam script and they see cases underlined, they see headings underlined, they see a person who understands the topic before they even start reading.
So you want to underline the cases?
Oh, absolutely, underline the cases. Because why wouldn't you underline the evidence?
Like subject sections, you mean, or just underline?
No, I would use headings.
Yeah, and subject.
So introduction and then a heading for, I don't know, what is the brand?
Sign, trademarks.
Yeah, and then, definitely underline the cases.
Okay.
Sometimes students highlight them, but I feel that might just be sort of like extra work for you. I don't think it's necessary. But definitely underline cases. Because can you imagine if someone opens a handwritten piece of work and they see several things underlined, you know immediately, oh look, they're using evidence. Now, if it's irrelevant, that's not going to save you, but the first impression is a good one.
When we're doing it like sort of informative,
Yes.
do you still want underlined or italics for the names?
Oh, whatever you like. And even if you don't, it's less important, because in any case you're very often going to have like a footnote marker after it. But whichever you prefer, that's a good question. And then you sort of go through. So again, and for this particular course, now obviously I would be asking this question in your other courses as well, because remember, the way that you're assessed and the thing that you're expected to do will depend on the particular objectives of the course as a whole. Now, in terms of this course, we've been looking at, particular legal rules in the context of brands. What are brands for? What are trademarks for? So someone asked me, I'm sure it was from this class a little while back, about, what you do with some of the sort of the contextual articles. For instance, works like the Lippmann piece or the Green piece and all these other ones. And the idea is that when in every single one of the sort of the aims and objectives, you have this bit at the end that talks about economic, social and cultural implications of scope of a rule, that is where that literature comes in. So again, this isn't me giving away anything, this is just sort of what we've done sort of over the course of the semester. And this is something that we're going to continue to do next term as well, when we look at our sort of specific themes to do with individual branding or the Olympics or GIs or whatever it is. But again, I mean, this is what the formative is for. So this is something that, and again, what the what the exam revision is for. The only other thing to add, which I would normally also say in revision, is that I will accept any questions about the course, but they will have to be received by, I think, the last day of term, because unless there's something which I can answer, generally I won't be able to answer them once you actually have your exam. Because effectively, once you receive your exam, you've effectively gone into exam conditions already. So any sort of questions that you have about any sort of substantive content, you should ask me before then. If there happens to be any kind of question that I can answer, there will be like a sort of separate page on Moodle where I write your query and then a response. But obviously I won't use your name or anything. It's just that anything in the lead up to the exam, I want everyone to have it. So often, if you're asking me sort of a question, especially if it's a substantive question, during class I will often ask you to send me an email so I can then sort of think about an answer and give it to everybody. Any other questions about the exam that I can answer?
So the structure in the body of the, so we have like the introduction, then the
Yes.
body and the conclusion. Is it, so you described that we have to underline the cases, but when we have like different approaches for defining something, do we structure them like first approach, the second approach, and then like, or I
Not
really have no-
necessarily. You have to do it in a way that's logical for your argument. So you're building an
Okay.
argument, right? So let's say, hang on. Oh, in fact, I have a question.
Okay.
Let's just skip to the very last slide, which I suspect we now won't be able to, which I suspect we might not get to. Okay, so here's a quick coursework question. To what extent does the concept of due cause serve as a break on trademark ownership? Discussed by reference to. And actually, that should probably be critically discussed, because the words critically and discussed together immediately tell you that you should be doing more than just discussing the legislation and the cases, right? Because you need to engage with some of the sort of social or economic commentary about it. How would we go about answering this? What is this question about? Remember that today's class is about infringement. Okay, turn to the person next to you and try to figure out what this is, so I don't put anyone on the spot. And then we'll go through it, and I think this might be a good way of dealing with structure. You can look up the infringement provisions if you're wondering. Let's see what slide that is.
What do you think? Okay, so I'm guessing that you probably recall this from all the sort of the endless discussion about trademark dilution and well-known brands, or well-known marks rather, where there's this idea that even if you're in a different class of goods and services, you're not to use a well-known mark in particular circumstances without due course. So the first thing perhaps I'd be interested to know when you were just having that discussion is, what is this question actually asking? So how do you rephrase this into an introduction? What's this actually about? To what extent we can use this concept?
Mm-hmm. So why does it matter? What does this concept do? Mm-hmm.
To what extent we can use the due course to limit the right of trademarks priority?
Okay, and so what is the effect of that? Why does it matter? Is sort of the underlying question. Why would that matter?
Is the scope of due course to prevent prevent the trademark rights
Yes?
to
To prevent what? Because you're
prevent-
absolutely on the right track.
infringement.
No, not quite to prevent infringement. You use it as sort of, it's a little bit of a shield for the person who's infringing. So who's it protecting, potentially?
The allegedly infringing.
Yes, exactly. So if it's potentially,
Opponent to the trademark.
exactly,
owner.
so if it's potentially helping the defender, the defendant, why might this be useful in the context of sort of circumscribing the scope of a famous brand's power?
Because I remember that in the textbook, the author mentioned that there's not exactly the specific provisions about what is the defendant of a trademark, like can it be used to express freedom expression? No, there's just a fundamental mention about that, but there's no specific right to the defendant. I mean.
Yeah, so actually, so it becomes a sort of way perhaps to ameliorate some of the strictness of what the dilution provisions do. So perhaps plugs a little bit of a gap where you might otherwise need to go to other defenses or to use, say, freedom of expression, but this is something that's actually baked into the particular right that the well-known mark owner has. So it's a question about the scope, the different scope that competitors have to sort of to interact with each other in the market. So you have something that, as you know from L'Oréal and Bellur, is very broad, right, or potentially is a very powerful right, and something like due cause, at least arguably, places a brake on trademark ownership by ensuring that you don't sort of, in some sense, automatically get protection just because you're well known. And you know, you could go through then in terms of structuring by saying, well, what is our key case here? What is our key case for anything to do with the well-known marks? We've genuinely mentioned it every single class, probably. Yes, it is. Exactly. So L'Oréal and Bellur would be a key case to be discussed here. So you can talk about the concept of sort of well-known marks. You can say, well, is this something that's helpful? Now look, your answer could also be, on the one hand, you know, it does all of these things. And then the next part of the essay could be, but on the other hand, that's not actually that useful for these reasons. Or maybe we would need to look somewhere else. So you can sort of weigh it up. Just because you're arguing for something doesn't mean that you have to have like a straight argument for one thing. You always want to be looking at for and against, which doesn't actually seem like that different to what was being described in relation to the exam approach that, for instance, you mentioned earlier. Yes?
See, this is the thing, is like when I was speaking to him, like with their system, they've got a very objective, like take a stance and go through with it. Whereas, like, because I did my law degree in London, and ours was always like give a counter argument, make a case, give a counter argument. Whereas they don't have that order. So do you want a counter argument like in the essays?
You do want a counter argument.
Yeah.
Yes.
Because they don't have a counter argument, which is why.
No, we have, but it's I mean like it's different structures.
Okay.
So we have like we're discussing the case in the. It's a little bit.
You know, like how
So
we
I
always advise.
genuinely, I wouldn't get sort of hung up in what I think end up being sort of stylistic differences.
Yeah. Okay.
Because there is, I mean, most of you, except I think for a few of you who studied in Scotland, you've effectively done the same things, just perhaps in slightly different ways. So I wouldn't in particular worry about it. If anyone is concerned about it, I think perhaps the best thing to do is, for example, you have Ilana Pima's article on due cause, or the other ones. Go and read a short article that you like and see how they do it. They have headings and subheadings. Look at the way they use the evidence. So, in other words, if you want to know what a good essay looks like, just look at a journal article that you think is convincing.
There are classes in the university for essay writing as well, if you want to send.
I think there might be for you. I'm not quite sure, but I thought that there were things that were offered. Certainly, there are also sort of books in the library relating to legal writing. So if this is something that you're not aware of so far and you'd like me to like put a link on Moodle or something, then just send me an email, and I can do that. They're just sort of short books. I suspect they'll end up being more useful to you when you write your dissertations, but also probably they'll be useful when you write, at least some of you will have essays due in January, for example. So it might be helpful. So can someone agree to send me that email so I don't get lots of them? Anyone? Who mentioned it? Who mentioned the thing about the, you, excellent. Can you send me an email about the resources?
Yeah,
excellent. Thank you very much.
Can you read about what, sorry?
About links to resources on essay writing.
I am fine with it, but if you send it to me, I will share it on Facebook.
No, I'm going to put it on Moodle.
Oh, okay, cool. Thank you.
It was just to prevent sort of 10 students sending me the same request. Okay, so just to go back to now my announcements, I'm going to slightly sidetrack, but I think this is probably quite helpful. The next week is a reading week because we finished trademarks. The week after that, we would ordinarily do passing off. Given that strike action has been called, and given that I suspect that it will go ahead, that class will be cancelled, which I will say at the time, because I'm going to be participating in the strike. I don't need to tell you this, but I'm telling you because you're my class, and I think it makes sense for you to know to show up. So the strike is about two things. It's about changes to our pension, but the second stream of it, well, an ongoing one, the technical details I will spare you. But the second one is about working conditions, in particular precarious contracts for staff members who aren't actually, I'm in a fairly lucky position. And that part is in particular about new people in particular who come in, people who are my future PhD students and my future junior colleagues. I want them to work in an environment that is helpful, that allows them to do their research, but also in a way that is better for students, because our particular conditions, you know, this is something that we pass on, and we want to be able to have time to
Will more classes be cancelled, or is it?
This will depend, I suspect. But certainly, so this is something that usually I would put an announcement on for Moodle just before, but I'm sort of telling you now because I realise we have a reading week, and then potentially our only additional classes now, the revision one. So that's the one I'm passing off. I don't intend to reschedule it. I should just make the obvious point before somebody asks, if we haven't covered it in class, it can't be on the exam.
It can't be.
No, because we haven't covered it in class. I mean, I think that would be a sort of new level.
That's not
sort
a
of
thing in Germany.
Yeah.
They will still do it.
They will still do it. Yeah.
I did not know that this was an option. I'm still not going to do that, but I did not know that this was an
So
option.
when is the strike?
It's the opposite. It's not the class, it's the exam.
So I'm just going to believe that this would be beginning on Monday the 25th.
So not this one, the following one.
Yeah, but next week for us is a reading week, so I wouldn't be able to tell you this then, so I'm telling you about it now. Obviously, you know, if you have questions or concerns, you know, let me know. This isn't a sort of a, I don't expect agreement. It's agreement, sort of one way or another. Okay, are there any other questions about the course? About this particular part of it in relation to trademarks? Okay, so I'm hoping that in today's class, based on what we've done, is to have a look at, hang on, that was the end, wasn't it? To have a look at infringement and defences. A lot of what we've done so far is we've started from, you know, you're a brand owner, how might you protect yourself? And to some extent, how might you protect yourself from, say, other people registering the same mark as you, for example? What we've done in terms of the relative grounds for refusal, as you know, because you participated very well in terms of the debate about this in class, these mirror the infringement grounds. So actually, this stuff is stuff that you know already in a number of respects. because really the case law for infringement and the relative grounds for refusal is effectively a mirror. Now, of course, with all of this, when we talk about sort of trademark owners' power, for instance, and obviously this has been a theme that we've looked at sort of across the entirety of the term, you know, how does someone defend themselves against an infringement action? It might be that they use invalidity as a sword. So remember, you say, you're suing me for trademark infringement, I'm just going to turn around and say, actually, your trademark was never validly registered. Or they seek to revoke your mark. Or they might be able to make use of a variety of defenses. Now, all of this, of course, everything, as you know, comes back to the trademark functions. So we started off the course, of course, talking about, well, what is a brand for? How are they able to exercise their power? Which part of that power relates to particularly the exercise of trademark rights? And one of the specific ways of doing that is to be very careful about how the trademark is used by others. But this whole question of use as an infringing use only comes up because you're damaging the trademark functions. If someone is using your mark and the functions aren't in some sense being damaged, we're just going to leave aside the stuff we'll do next term around like freedom of expression and parody and that sort of thing. Unless they say damaging, in particular, the origin function, you know, there's nothing for the law here to do. But of course, what exactly a use means and whether you have a sort of defense to it is going to be sometimes difficult to identify. So there's a few sort of steps to keep in mind. The first is that you will always, when we're talking about trademark infringement, we're talking about registered trademark. So you will need to, at the very first point, identify what the registered trademark is. You will then need to identify, well, who it is that you're suing and what their sign is. So after that, you have to say, well, okay, they have a sign, but where is their sign? Have they put it on packaging? Are they using it in advertising? In what way are they using it? The next step is going to be, well, unless I suppose you're a well-known mark, are they even in the same class of goods and services as you? Right? There's no point in suing someone for infringement unless perhaps you have a reputation. If the court's just going to turn around and saying, well, you sell bricks and they sell chocolate bars. You know, there is no problem here. And then finally, you'll need to, although perhaps this seems obvious, you will need to demonstrate that the use is, as mentioned here, in the course of trade. So again, leaving aside what we'll do next term around, you know, can you use trademarks in paintings when you're an artist? Generally, the kind of problem that comes up is, well, you have competing traders. Pretty clearly, you know, someone is selling something. You're using it in the course of trade, but it's important to look for that specifically. So this is a summary. I've put this on Moodle, so I'm not going to discuss it particularly here. And this is what I want to go through. I want to start with section 9 of the TMA, which simply says, when you're the trademark proprietor, you have the exclusive right to stop other people from using your mark. This is also the basis for your ability to then sue people for infringement. And again, to just summarize the steps, it's going to be use of the relevant kind, which I'll come to in a moment, in the course of trade. What are the different forms that this might take? Well, you might use it, these look familiar, right? Because they're basically the relative grounds for refusal. The first one is double identity. They are using an identical sign in an identical class. Or it's an identical, similar class and sign, plus there's confusion. Or it's a well-known mark where there's reputation, and they're using it that way. Now, in practice, Section 10 gives us the different types, or these are some of the different types of use of a sign. Now, the most obvious one is, you have put it on your particular packaging. So you've put it on the product. You've imported, you're using it as your company name, you're using it in advertising. Now, this, of course, brings us back to the very start. Someone asked me in the last class, in relation to that topic, can you use Arsenal and Reed? The answer is that yes, you can always use Arsenal and Reed. This is another example. And use is defined here as creating the impression that there's a material link in the course of trade between the goods concerned and the trademark proprietor. What is the trademark function that's at issue here?
Origin.
Yes, yes it is. This is origin. So a very sort of straightforward explanation of this is what use means, why does it matter? Because it implicates the functioning of the trademark as a badge of origin. In the same set of cases, but you'll notice this is back in the UK courts, that point is made very clearly. So exactly when I said, well, what is the origin? It's likely to affect the functions of a trademark. So again, it's not enough ever to simply identify use. You need to identify use that's infringing. So just use by itself is not actually very helpful in terms of you identifying it. Okay, so I think maybe I may have mentioned this one already, perhaps earlier in the term. Yes? Why? Does anyone remember what this is about? I mean, you have the question right, so I think we sort of have a clue. Is this...
They use the sign. And
They are using the sign.
for a toy without consent from the owner.
Right. So let's say that they're using the little sign without the consent of the owner. The question becomes, though, is this an infringing trademark use?
You see this a lot, but not infringing.
Okay, someone said not infringing. Why?
The judge says because of the toy card should be actually look like similar that the one, because this is the toy's function.
Yeah. So it's essentially, how else do you do a miniature toy? Exactly. It's functioning as a toy, and the idea is that what you're doing is you're shrinking a big car and you're making it into a little car, and of course you're going to have to use the sign. So the next question then becomes is, does it seem reasonable in light of what we think trademarks and brands are for?
No.
Really? That's quite strict. How
Because
come?
it has same features of the real car, and it has like a trademark of the company. So for me, if I'm going to buy this one, I might think for a second that the company made this one.
Yeah. This is possible.
Yeah.
Mm-hmm.
Could be, I'm not sure.
I think the function of advertising. So a company can advertise a car via a toy. So they provide toys for advertising, like you said, their own cars. For example, Audi R8. If you gave it to a child as a present and he's growing up, okay, I know it's really thinking too much forward, but if you're giving a child as a toy and he's going later to buy it because he was, it's a kind of advertisement.
So like you're saying, you're basically, you're
You
damaging the
influence.
advertising function because you're trying to influence children early to then buy
Yeah.
that car afterwards.
I know it's.
Yeah, no, I mean, so these are the other things, but then, okay, so just building on that,
No, sure.
if
it's not
we
hard.
accept these arguments, so in this particular case they hadn't talked about advertising, they just talked about the origin
Yeah.
function. If we accept that argument, does this seem an appropriate extension of brand power. Think about it in the context of other traders and potential competitors, as well as consumer welfare, which is sort of the two things that we've looked at. Yes?
Yeah, I think the more concern about the consumers' welfare because they don't think there will cause the confusion of consumer to the link of the real car to the toy car. And according to the handlers of German practice, business practice, so they are judged by the consumers.
Yep. Okay, and now building on that again, so this is like sort of a long way of saying, okay, fine, if the core of this is, say, consumer confusion, or whatever it is, how do we place this into then its sort of broader social or cultural context? Are we saying, if we take the position here to its logical conclusion, we can't have miniatures of anything unless they come from the original trader, yes? So what's the counter-argument?
Without the sign, they put the sign on the small cars all the time. Like they can use and mix same features, but without using the sign. The only problem is about using the sign of the company.
Yep. No, totally accept that point. What is the counter-argument to this? So let's say that if we're being super strict, we can never have miniature ice cream with a Magnum logo on it. We can never have miniature cars with an Opel or BMW logo or whatever it is. We can never have miniature coffee cups with the Keep Cup logo on it, right, as toys. So this is argument you can say we're going to be super strict. In the interest of consumer welfare, we could argue that a super strictly interpreted badge of origin function means that we can't have any kind of use that might suggest confusion. I actually think that what you might all be talking about is likelihood of association rather than confusion. But this is a fair argument. What is the counter-argument to this?
It's not confusing.
No, even if it is, potentially.
Okay.
I was thinking about that the likelihood of confusion has to have that, for example, similar goods and also similar services. For example, you cannot drive the miniature of the car, obviously, and the original car is there to be driven, and also the big ice cream is to be eaten, but the miniature is just like a miniature.
Okay, let's say they're in the same class, which is possible.
Yeah.
But yes, so they're indifferent. So let's say that even if there is a likelihood of association, I completely accept your point. I mean, they are completely different things. So, what is an argument for not giving such strong protection in terms of trademark use?
You then give the proprietor so much power over that market that becomes that they can't be new entrants.
Right. It becomes an issue for market power is one of the counter-arguments. So you end up with the potential monopolizing possibly into other classes, possibly into preventing particular uses, so it's anti-competitive.
Not really monopolizing. You just don't want your sign to be on a toy. It's just not really monopolizing.
Protecting the sign, that's it, in the market.
Even if you end up with less variety of toys. So imagine that maybe they're not cars. I'm trying to think of something that might be sort of more
Sometimes they
significant.
use on watches as well, like you see BMW watches or Mercedes watches, and they are manufactured by the company, but you see like the fake ones as well. So they use the sign for like a different use, not only for the toys.
No. So this is fine. So I'm saying that if we think that this is wrongly decided, and so here the suggestion here is that this isn't a use of the necessary kind because it doesn't implicate the badge of origin function. If the argument is that all of such uses must necessarily implicate the origin function, the counter-argument to that would be this one about sort of market power. You suddenly have a sort of bracketing off of particular signs. Now, when you think about this, say, in the context of the informative about the distinction between a sign and a brand, what is sort of the broader impact of such strong protection, what would it be? Think about this in the context of Lippmann's work on communication. So one of these is economic, to do with market power. What are the other ones? What are other contexts that we've spoken about? In like literally the first class, which I realize must sort of feel prehistoric at this point. What's that?
Protection of customer.
Okay, but how?
I don't know, it's right, because I'm thinking of what's the prediction of the view of the customer.
Right.
Maybe like they really wants to is kind of car, small car toy, as much as similar like the actual one. So actually one of my cousin, he really liked that cars toy, and what he actually searching for is the real car, smaller size.
Yeah.
They can open the door, even the inside or the shape are actually the same. So what's the toy collector actually want is the similar size, or even more as the same.
Right, and this particular activity, right, not necessarily an economic activity except for the point of sale, but a cultural activity. So your point about communication, the other side to add to the economic counter-argument, I suppose, would be, well, if it remains completely with the brand owner, to what extent does that prevent certain communicative uses, beyond sort of other traders? So your ability to sort of engage, sort of with particular aspects of culture to communicate by the use of marks. So that would be the counter-argument relating to brand power. Yes?
It actually also shows how powerful the mark is, because I'm going to bring back again the Louboutin thing. If there is a black bag and the inside is red, people will assume that it has maybe something to do with Louboutin, but that's actually because the brand made it like so obvious that this is their trademark. I don't think you could tell that, like you could say that the bag is that the trademark, the use of the red sold actually, but the combination of red and black, that this would be used. It's just again this cultural thing, like how we understand brands and signs.
Yeah, and so I think the additional point to that is actually this one about co-creation. So depending on your position on that, you might actually say, well, if in part the power that a particular brand has is created also by the consumers, it doesn't make sense that all the power to regulate its use should lie only with the brand.
So what is the main concept here? Is it like the consumer, or
so
if the consumer confused about the product?
So can I just add that we're talking about at sort of several different levels, and at every level we may reasonably disagree. So no, in terms of use here, these would be the kinds. Double identity, this is just like the mirrors to the relative grounds for refusal. Yeah, so that's all we're looking at, really. It's not that different. Okay, I've mentioned invalidity and revocation. If you're not using it, obviously, then it's not going to matter very much. What that brings us to then is specific defenses. So again, just to sort of recap before we move on to the defenses after a wee break. When we talk about use, you need to be able to fit it into one of the categories. So confusion won't always be necessary.
Confusion.
No, it won't always be necessary. It will only be necessary on the second ground, not on the first one. For double identity, you don't need confusion. Obviously, the confusion is sort of implied, right? Because it's identical sign on in an identical class of goods and services. You only need confusion on the second ground, which is a similar identical sign, similar identical goods and services class. Does that make sense? Yes. Okay, excellent. Let's have a 5-minute break, and then we'll come back to the defenses.
By yourself? Yeah. I don't know what you
defenses, right, for infringement. So this is very much about, so when we talk about sort of these big issues about what can trademark proprietors do to protect themselves, how might they build their brand, something to take into account is that you could have a registered trademark. It doesn't mean that you can prevent everyone from using it all the time, because they may be able to raise a defense successfully. And once you've identified that there's a use of an existing sign, just to be aware that the particular defenses we're looking at are the use of a name or address, and then these sort of non-distinctive or descriptive uses. I think perhaps the thing to highlight as a sort of fundamental issue here is that in relation to both of these, in relation generally to the defenses, you have to show that it's in accordance with honest practices. Right? So you may be using your own name, and you may want to use it to defend yourself against a trademark infringement action. This will be useless to you, basically, if you're not acting honestly. So every time you look at the operation of a defense, you have to say, what is the specific defense, and is the use in relation to honest practices? So in other words, you can't look at any of the defenses unless you also consider whether it's honest. So there's always sort of the two-step process. Now, okay, the earlier right, we will know what that is.
Excuse me?
Mm-hmm.
I
Yes.
just want
Yeah.
if the defenses of the own name, does it mean that not only I can use it, but also I can register? Or I just can use it?
No, you'll be able to use it. Chances are you won't be able to register it if that already exists. But you might be using it in an unregistered way. You might just like own a shop. So we'll look at an example of a shop that happened to be using a particular name sort of concurrently. Okay, so type of use. When we look at uses in relation specifically to the own name, we're looking at use by an individual of their own name or address. Now, the thing to highlight here is that this is a change from the law previously. So we're still going to look at some of the cases where the own name defense could be used by companies. And I mean, look, I think there are also questions here about whether this change was an appropriate one, right? Is it helpful actually to have the own name defense only for sort of individual persons, whereas before, when we referred to a person, who else could we be referring to? Or what else, rather? What's the legal definition of a person?
Legal person.
Yep, and what does it include?
Like a normal person?
Yeah, so all of us. Natural persons, and what else? Yes. Yeah, it would include companies. So legal persons. So the previous version of this defense was broader. What we have now is the reference to an individual and not a person. So it's narrower than it was before. It's not simply for companies. Those cases are still relevant, especially insofar as we can contrast the cases where a company is using their own name with the cases that we will get now, where we're simply looking for an individual. So a natural person, that's made clear in the EUTMR. So that's the first defense that I mentioned. The second one is about using the sign to indicate the quality of something. So to describe it in some way. So in a way where you're not using it in a distinctive way, such as to affect the badge of origin function, but you're simply saying something about the kind or quality or the purpose of the goods. And again, just to make very clear, this will only work, these defenses in section 11 are only going to work if your use is in accordance with honest practices in industrial or commercial matters. So in other words, basically, are you dealing with your competitors? Are you dealing in the market fairly? And there are a variety of cases that deal with this. So one example of this, when we think about this question of, what does it mean to act in accordance with honest practices? And in this case, we had, this dealt with the names for bottled water. And I think this might be another one for our German friends to pronounce.
Gerolsteiner.
And the short version of that?
There is no shame.
Yeah, I don't know the version.
So I think that the suggestion was that they were maybe a little bit close, as in like Jerry, or Jerry, and Kerry, which is the second bottle of water. Look, I'm not, okay, they're probably not that similar, right? But anyway, they were upset. So you have Kerry Spring importing the water, right? So let's just leave our skepticism aside for a moment about the pronunciation. There was an argument about whether this was an infringement, but that is sort of less important than, even if it is an infringement, could you just say that you're acting honestly? And the argument seems to be that yes, because all you're doing is you're saying, well, actually, this is actually where the water comes from. Kerry is a place in Ireland. That's where the water comes from. All you're saying is that you're describing where it comes from. You're not using, you're acting honestly. You're describing the thing that you're selling. You're not in fact, again, you're not in some sense acting poorly. So in terms of what it means for a practice to be honest, you are, in this case, the argument goes, acting fairly in relation to this trademark proprietor. And the reason you're acting fairly is that you're not doing anything other than just saying, well, this is actually where the water comes from. So there are a couple of steps that we can see in this case that we might need to look for. And the first is that we would need to ask, the same as I suppose in the infringement steps, in terms of whether it's honest, is would the particular public, the sort of bottled water drinking public, would they think that there was a link between these two traders? I mean, the skepticism from certain corners of this room suggests that probably not, which was the case here. And then second, which is interesting in relation to honest practices, about whether or to what extent the competitor, the second trader, was or should have been aware that there might be thought to be this kind of connection. So in other words, you may be found to be acting sort of dishonestly if you're sort of exploiting perhaps some kind of confusion that there might be amongst consumers. Now, obviously, perhaps the counter-argument to that is that everyone can act honestly and consumers end up confused anyway. So, perhaps the defense isn't quite as clear as it might be. So, in other words, what the court says here is that just because there's a likelihood of oral confusion, it doesn't automatically follow that a practice is dishonest. This makes sense, right? Because otherwise, every finding of confusion would negate your ability to raise a defense. Right? So for honest practices, you're going to need to show a little bit more if you're the plaintiff. So similarly, in this case, and actually this is one. So I don't know. Can you see that? Maybe not that well, but you have the producer of razors. And you have someone else who comes in and says, actually, our particular razors are compatible with the first one. So the Paris and Flexer razor turns out to be compatible. You can sort of mix and match in whatever way. Is this an honest practice, is the question. So whether it's in a razor or in something else, you're saying, my product is compatible you know, in this case, these particular handles are compatible with the razors produced by my competitor. Is this an honest practice? Yes?
Might be.
Why? Why?
Legally, I don't know, but like there is an example for
Okay,
the coffee.
let's
for
go
the
with
coffee
the
machine,
intuition.
same, yeah.
Okay, your intuition is correct.
Because like I can give just example. I don't know like from the legal perspective. For coffee machines, you see it's written on them. It's
Mhm.
compatible with Nespresso, which is like separate brand.
Yeah.
And it's okay when you go to Nespresso and as they say, yeah, you can
Okay.
get that one and you can use ours. So
Right.
it's like there's no problem.
So, you say that you don't know what the answer is legally, but that's not true, right? Because we know what the functions of a trademark are. So bring everything back to it. If you're saying this is compatible with these coffee machines, or this handle is compatible with these razors, is this affecting the functions, the distinctiveness?
Of course it is, because basically that one, which is just compatible, might be cheaper than the actual one. So the customers might buy the cheaper one, which is still compatible with the one they have. So it's actually very like a negative thing causing for the economy of the trademark.
Yep, this is true. It might be terrible for their bottom line, but trademark law doesn't care. Because they're like, you're expensive, you're losing money, not their problem. Because actually people would still know which one they're buying it, who it comes from.
And at the first
So it will protect you, but only up to the point, but not perhaps to stop you from losing money, although completely agree, this might be a bit of a problem for you, because you'll be like, yeah, why would I buy the expensive one? Like, why would you? I'll just buy the one that's cheaper. So why isn't it problematic in terms of distinctiveness, in terms of the badge of origin, saying this is compatible with?
doesn't really affect that brand. The consumer has like choices, so they can choose one of them to buy.
So what's it doing? Mhm.
Well, it's clear it's not from the same producer. It's just compatible.
Yeah.
Yeah.
Yeah. So it becomes this question of, well, we're not saying that we produce those razor blades. We're just saying that you can use them for this. Now, before anyone says it, obviously I think that this is what happened in L'Oreal and Velour, right? And yet they were like, well, you couldn't possibly. So, you know, example 457 of how context specific these particular cases can be. But just as a sort of, as a contrast, I think you had a
Yeah, I just wanted to say that I think also because in the book it said something about technical requirements. So for example, this
Yeah.
is a normal razor. They couldn't say this is so much, like you just copied the same razors as ours. It's just razors which are compatible with the other one.
Yeah, and actually this is a really important point, right? If there's no other way for you to demonstrate what the technical qualities of your thing is except to do this, it's very difficult really, isn't it, to say that that's dishonest. Because there might literally be no other way of describing, you're absolutely right, like the technical function of the thing that you're producing, except to say, you know, this other person's, or this other company's name. Okay, what about this as an example? Because this was on your reading list. Can anyone tell me what this was about? This was a contrasting example.
It was it used to be a Volvo dealer, and then they lost their license to deal Volvo, so they changed their sign and the logo on their papers to independent Volvo specialists. And independent and specialist was in much smaller writing, but still visible if you looked at the sign. They get sued because of using the Volvo trademark. And their defense was that due cost, I believe, at least it was about they had to use the trademark to show what they were actually doing.
Yep.
But because of some letters they sent to their customers, the formulation in the letters and the writing was found to be dishonest, because they wasn't actually clear about that they were no longer
And so, by contrast to the other case, you could say, yeah, this isn't, what they're really trying to do is to create this confusion because this way customers will come to them thinking that in fact they're in some way still affiliated. So this is sort of the flip side to that. So they're saying, yes, you can describe the thing that you're doing, but you can't just go so far as to, in some sense, act dishonestly. And yeah, in this case, they were, apart from the fact about using the big letters and the little letters, they were sort of sending other materials and such. And this makes sense. So this brings us then to, again, honest practices are going to be relevant. This brings us to this question of the use of the own name defense. And I just wanted to raise just here, before looking at sort of own name in a little bit more detail, is that, and I don't know, maybe this will come back, but there was an attempt to challenge this trademark rule change about, limiting it to natural persons, and that's not been successful. So again, maybe this is something that comes back, but in any case, there wasn't a preliminary reference made, as you can see in the 2018 case. So not perhaps something for us for this year, but maybe one for you to look out for. I'm just going to skip over bad faith to come to the Celine case. And this is an example of the use by a third party of a company name in Celine. Now this relates to the use of a shop selling clothing in France. So basically a clothing boutique, it has the name Celine on the shop front. So this is they've been using that particular name in those particular premises since 1950. Who do they get sued by? They get sued by the luxury fashion trader Celine, who incidentally have had a registered trademark for quite some time. I did find one which was definitely, I think I mentioned this before, from like 1948. So there's not really an issue here about, they weren't registered or they hadn't protected it, they had. And so they sue for trademark infringement. We're just going to leave aside sort of French issues about unfair competition because we're not dealing with that here. And of course the response is going to be, but I'm just using my name. This is the name that I use for my particular shop. Now, obviously, insofar as that's a company name, that sort of defense isn't going to work now. But in this case, it was quite useful. And this is what the court had to say about it when it was referred. So the unauthorized use by a third party of a company name, which is identical, constitutes use which the trademark proprietor is entitled to use, is entitled to sue for infringement for, where the use is in relation to goods such as to affect the functions of the mark. So I'm wondering what you think about that. Is this a trademark use? Is it in one of sort of the list of things? Just leaving aside the own name, is this a trademark use? And if so, is it being used honestly? I'm wondering what you think. So this is a fairly sort of standard kind of trademark example you get. There's a small shop somewhere, but it turns out that they have the same name as, name a big corporation. Yes?
But Celine is like a normal French name, so the person could just claim that it's his personal name, and they just wanted to have the personal name of the brand.
Yeah.
Or the shop.
Yes, and that would be the first step. And then the next question is, assuming it's their real name, which is fine, is it in accordance with honest practices to use it? What do we think? Big clothing trader, clothes shop. You can sort of see like a sort of small film being made about it. Anyone? Does this seem honest. I don't have resolution for you, by the way. From what I can tell, and my French is basically non-existent, is that eventually a French court ruled they had to stop using their name. And then there was sort of various bits of sort of public outcry, as far as I can tell. But do you actually think that this is honest? Is it? Yeah.
Depends on the needs, right? Maybe they are using the name to promote or to get more sales.
Well, I mean, yeah. So I guess this would be part of it. Are they sort of actively, do you think they're actively trying to confuse anyone? Or trying to, so this goes back to this question of, especially when you have a well-known mark, is this an example of riding on the coattails, of the mark with the reputation? So again, something to think about. It won't necessarily be easy, and certainly unless you can demonstrate that this is an honest practice, and I think the argument could go either way in a case like this, it won't actually matter that it's your own name. So the own name defense is very useful, but you're always going to need to look at it in the context of what your commercial practice actually is. Now here's another example. This again is before the rules about an individual name. And here you have a hotel owner and a defendant. So this is a hotel, and a defendant who starts up a restaurant, and they both have the same name. And the question was here, well, is this just you using your own name for the restaurant? Is this in accordance with honest practices? What do we think about this one? Would this be okay?
Maybe I think maybe we can use the same strategy like in the vault, like how the design of the sign, and is that similar? And in this way we can deduce whether the owner of the little one is honest or not.
Yeah, and so they're actually basically saying, how you're using it, it's very similar. You can apply the reasoning in the Volvo case. It turned out that in this particular case, the thing that scuppered them was that it turned out that it wasn't actually their name. It wasn't actually the name of the company. So they said, we're just using our own name, and they said, hang on, you're called something completely different. So they weren't allowed to use it. And suddenly it seems like a little bit dodgy. And you kind of think, hang on, why have they happened to just choose this? But in other situations, then you would say, actually, is this sort of similar to the Volvo case or to the other ones? Okay, so that brings us to the Assos case. No, sorry, I just wanted to, before, in the Cipriani case, they mention the Reed executive case, and I thought that this is quite useful just as a summary of sort of the sort of thing to look for. So about whether you're being misleading, whether you're taking advantage, but looking in particular about whether it's a deliberate attempt to avail oneself of another's mark. So when you mentioned the Volvo case, that seems to be what had happened there. This was a sort of a deliberate attempt to use Volvo and to sort of create this confusion about whether there was still that sort of association. So if they're doing that sort of deliberately, they're being misleading in some way, this is not going to be an honest practice. Okay, so that brings us to, now, okay, obviously if it turns out that the person who's suing you hasn't actually used their mark, you're obviously going to be fine, because, they just shouldn't be suing you full stop, because it turns out there's no problem. Now, this brings us to the Assos and Assos case. Now, how did everyone find this? Because it's quite long, and there seem to be about 20 different things going on in it. Would that be a fair description of reading it? Yeah, it's quite a challenging one. So what I'd like you to do, basically as a sort of first thing, is in small groups, just to see what was roughly speaking the issue? There were multiple ones, but to focus in particular on this issue of, is this just people using their own name? Does this seem to be fine? So specifically, can ASOS use the own name defense? Were they able to use the own name defense here as against the cycling clothing manufacturer? So we'll just do that for 5 minutes. Again, I don't expect everyone to sort of be able to be completely on top of the detail, but just to zero in on that particular point as well. Just on that particular point. So what, roughly speaking, was at issue here? And if there was an infringing use, was ASOS able to use the own name defense? Yeah, just to make it a bit easier. Okay, so let's have sort of 5 minutes for that. Except that, you know, it's going to take like an hour. 1, 2, not bad. I'm guessing that most people have probably heard of the second trader. Yeah. Yeah. Okay, so what was the problem here in very, very broad terms?
Similar trademark with similar goods or services.
Yes. So similar trademark, one has a double S, one has one S. Similar goods and services in relation to clothing. And now, of course, there's a lot of material in the case around, you know, what is the actual specification of the mark. There was also this question of the fact that the mark had changed. So I'm just giving you the examples here because I think maybe if you've printed out the case or you looked at it on Westlaw, I'm not sure that the pictures come up. They might not. So these are the pictures. So when the court says, oh, the trademark changed, it went from that to that, which suddenly looks, at least arguably, a little bit more similar. So just to sort of give a, when you see like the visual representation of it, I think it gives a sort of better sense of why the first ASOS will have been sort of bothered by this. So this is why when you've just raised the point about similarity, our first ASOS alleges that there's a use of a similar mark without due cause, that it would cause confusion, that unfair advantage was taken, and just, you know, because you want to leave no stone unturned, they say, and in any case, you invalidly registered this mark. So it's just sort of like the full arsenal, basically, directed at the defendants. This, by the way, is why this case is difficult to read. It's not that sort of like, if you picked out an individual bit and followed it, it sort of makes sense. It's that literally everyone is throwing everything into the claims and the counterclaims that they possibly can, including passing off. And this is why when ASOS responds, it says, well, even if there was infringement, there was no confusion, they used their sign honestly, they used their own name defense, that's what we're looking at, and that there was goodwill, and we'll just leave that aside for the moment. So looking in particular at this question of the own name defense. Now, at first instance, the court says, well, there wasn't infringement, there wasn't passing off, and so one of the appeal grounds is, well, should the trademark specification for ASOS double S have been restricted to specialist cycling clothing? Why does this matter? It matters, remember, when you're looking at the use of a mark for the same or similar classes of goods. It matters whether your clothing for racing cyclists can be folded into this sort of casual clothing generally. Because if it can, you're obviously using the mark in the same class of goods. So on appeal, on that specific point, the court says, actually, we're going to broaden your trademark specification to specialist clothing for cyclists. So deleting the word racing cyclists. So it broadens it out, finds that there is in fact infringement because of this likelihood of confusion, but there's a defense of own name by ASOS that's actually made out. Now remember, this is before the rule change around individual names. And so one of the questions which I'm hoping you might have discussed is, does this seem like an honest practice, their use of their name in this regard? And more to the point, is this something that we should have allowed to continue in relation to, you know, the operation of the trademark laws? Yes.
I thought that the funds of own name means like literally using my name and my passport, or like let's say my first name or my surname.
Oh,
But
interesting.
ASOS here is actually, it means as seen on screen. So I thought, you know what I mean? Like I thought the funds of own name is like your proper name and not something you made up.
Okay, so yes, so it would be now, but under the old rules, you could use your company name, and the contraction for the company name that was registered was actually ASOS. So at that point, it would have been fine. I mean, I think that we could argue that actually we shouldn't allow companies to use this defense at all. Because I can understand that the intuitive response is it must just mean your actual name. You know, not a legal name like a company name. Does this seem appropriate? What do we think? Or put another way, because everything comes back to the trademark functions. Does this outcome, at least in respect to the own name defense, does this reflect the trademark functions and the rationales for trademark protection? I feel that really I can't let you go unless I have at least 2 comments on this.
Kind of down the middle, but arguably no, because the clothing wear companies, like deciding retrospectively that the category should have been smaller, more specific, seems a bit of a getaway, get around to allow ASOS, the larger company, more well-known company, to keep trading.
Ah, that's interesting. Okay, yep.
Can you repeat it because you didn't hear it?
Yes, please do.
Sorry. Just that it seems a bit of a get around to sort of decide retrospectively that the specification was too broad, that it should actually have been a much smaller category. It seems like a bit of a convenient way to let ASOS, which is a lot better, more well known, to keep trading under the name despite the similarities.
Yeah, so there are questions here about, say, in the use of the name defense, about whether actually it matters in the context that you are providing this sort of additional power to a company that's already quite big. But is that then an argument for saying, actually, so to link to your comment as well, that we should just keep it purely for personal names? Because that possibly would have saved them here, actually, the cycling company. Because it's not an individual, right? Under the new rules, the outcome would probably be different. It's more of a rhetorical question. One more comment. Is this in accordance with our rationales for trademark protection?
We argue yes, because it's honest business practice.
Yeah. So putting it in the context of, you know, what are trademarks for, both in the context of regulating relationships between traders, but also sort of communicating things about the origin of goods to consumers, you could argue that this is an appropriate outcome. Thank you very much for taking sort of 2 for the team in terms of allowing everyone to go. The only other couple of points to note is that, remember, even after all of this, even if you can't make out any of the defenses, you could just say, actually, I'm going to attempt to revoke your mark. So that's the first point to note. But the other one is that if you, as a defendant, are unsuccessful, so you've not been able to revoke the mark, you've had an unsuccessful application for invalidity, you've not been able to make out the own name defense and honest practices or descriptive use and honest practices, you are going to be liable for damages in particular, but also potentially an injunction or an interdict. So you would be liable to be at the receiving end of a number of specific orders, which includes being forced to remove the sign from your goods, to destroy the goods that are infringing. I mean, this is quite sort of a serious outcome. Or to deliver up the goods to the pursuer, in Scots law terms, or the plaintiff in English terms. Now, obviously, this isn't required to sort of allow you to sort of personally go into anyone's property. There are sort of legal procedures around how you do that. But just remember that at the end of all of this, the sort of the end point of all of these disputes, insofar as they're legal disputes that go to court, if you haven't been successful, you need to sort of be prepared that you're probably going to be liable for damages, or usually damages or an interdict. In Scotland, an injunction. Elsewhere, basically stopping you from using the mark that's infringing. Okay, I'm going to leave it there. That's quite a lot. If you have questions, you can send me an email. Okay, thank you.